Okay, I'd like to do the treasure hunt to find out which room you're in for me to watch your transcription. So she does real time. So what that means is everything that she's typing in, I can see it on the screen. And you'll be able to see it sometime because it's running through my glasses. And it's people are like, what's running through her glasses? Is that the NASDAQ? It's not. It's her typing. But it helps me because sometimes if there may be something that I can't hear, or either I think an attorney is speaking too low, if I see her writing falter a little bit, I know that she can't hear and that people are talking over each other.
It's like a PSI.
All right, everyone. Oh, can you do me a favor? Can you have the clerk, Caroline, come out, please? All right. Hi, Jenny.
Good morning.
Good morning. Today is Friday's Eve. It's going to be a great day. It's always a great day when we see Robert Maurer.
All right. Big Robert. Take your wait staff and the
All right, everyone. If you'll have a seat, I am going to call the docket. When I call your name, please let me know you are here. I'm going to ask that you stand and answer the docket. If I don't know you're here, then I'm going to assume you're not here and a warrant may be issued for your arrest. In custody, we have Larry Haynes.
We'll be ready, Judge.
Thank you. Michael Moore. Thank you. Larry Berry. Thank you. Hi. So everyone, before I continue with docket call, I have some sad news. You know, I love the staff here. I think they're so great. Caroline is leaving us. Right? But she's going to be working in probation now. Yeah, so Bashan is very happy. So we're going to miss her. But we're going to have a non-surprise thing for her on November 3rd, because that's her last day. So we're going to. So we're going to miss you, Caroline. But we're going to be nice to whoever replaces you. Okay. But I'm going to say, Caroline would have done it differently.
Thank you, Jen.
You're welcome. All right, Devon Stryjet. In custody, we have Johnny Aguirre, Gracie Saganda. Thank you. Aiden Garcia. In custody, we have Roland Diaz, Jesse Solis, Pete Diaz. Christopher Lamar, custody. Michael Martinez, custody. Juan De Hoyos Garcia, custody. Jose Perez, custody. Emmanuel Castro. Gabriel Gobert. How do you pronounce that first name?
Yoquinto Leon.
Pianquito Leon.
No, that's just.
All right. Cornelia Childress, custody. Jeremy Perez, custody. Fabian Lee Cardenas. Thank you. Zachary Guerrero, custody. Darian De La Rosa, custody. Larry Haynes, custody. Cameron Lawrence. Cameron Jacob Lawrence. Oscar Martinez and Kevin Luna, custody. Aron Bawani. Thank you. And custody, Kevin Luna, Oscar Martinez. Oscar Martinez. Renee Gardia. Thank you.
Oscar Martinez is in jail. He had called him earlier.
All right, thank you. Michaela Johnson. Michaela Elise Johnson.
She's in jail as well.
All right, thank you. Michael Martinez, custody. Christian Smith. MC Reed.
Present.
Jared Pena. George Hawkins.
President Council, Your Honor.
Thank you. Leonard Johnson, custody. Frank Torres. Frank Torres. Thank you. Jose Castañon is not to be brought over. Jose Sanchez is in custody. Nicholas Ramos, custody. Is there anyone who came in late or your name was not called? All right, we'll start over here. What's your name? Miss. I'm sorry, first name? Do you know who your attorney is? Okay. Do you know your... What court are you supposed to be in?
I've been the one that you said in court, but I could be wrong. I don't have.
What's your SID number?
818-246. I did just get released about a day ago.
All right, 818-246. Just have a seat. We'll get with you. And if you're in the wrong courtroom, we'll let them know you were here. All right, anyone else on this side? Anyone on this side? All right, we'll get with you. And Mr. Cisneros, if you'll have them pull this file from the back. All right, everyone, today is Friday's Eve, so we should all be happy because tomorrow is Friday. To my left are the files for Criminal Trial Division. To my right are the files for family violence. I try to keep the courtroom as least congested as possible because there is a flu and pneumonia outbreak. COVID is still real. Leprosy is coming in from Florida. So you're like, okay. So just grab your file, and if you will place your file on the table and have a seat, the prosecutors will call you in the order in which you'll appear. To my left is the court reporter, her equipment. She's had to put sticky notes up that say, do not touch, do not lean on her desk, do not use that as your office, do not put your paperwork up there. If you damage her equipment in any way, you will have bought it, and that equipment is over $10,000. To my right, Michelle, can you raise your hand? That is the probation officer. Do not use her office as your desk. Do not put your papers on her desk. Do not turn your back to her because she's sitting down and she doesn't want to see that if you turn your back to her. Do not approach the court on a motion to revoke until you have spoken to her. That goes for the state and the defense. If you have a client who wishes to speak in a language other than English, yes, an interpreter needs to be brought down, whether you speak the language or not. So before you're ready, ask the clerk to call for the interpreter. Do not approach the court if you have not conferred with the state and conferred with your client. If your client is in custody, yes, they need to be brought out. Ask the deputy to have them brought out. Once you've requested an interpreter or requested it that your client be brought out from the back, do not leave the courtroom. The reason being, there's a shortage of interpreters. They can only be in a courtroom for so many minutes unless they're interpreting for a jury trial. In regards to the deputies, for security reasons, they're only allowed to bring out so many inmates at a time. And if you request your inmate and then leave, you're being selfish to your colleagues. The other thing, every attorney knows that's the door the inmates come out from. Do not block that area. Do not congregate in that area. The deputies need to be able to see. I've already given them permission. If something were to go down and you're in the way, what happens, happens. I'll sign an affidavit and your colleagues will as well. So as I said, today is Friday's Eve. It's going to be a great day. Please confer with kindness in your heart and a smile on your face. Everyone, please confer. So what's going to end up happening is the attorneys who have inmates in the back, they're going to be requesting that the deputy bring their inmates out. This is motion to revoke day. It is also sentencing day. So sentencing day, people have pled, a PSI has been done, and they want to know if I'm going to give them probation or not give them probation or send them to prison. And what will end up happening is probation will have what's called the pre-sentence investigation report. And people just for short call it a PSI. And in that pre-investigation report, it will again give a recitation of what happened with the offense. It may give information on the complainant if the complainant had something they wanted to say. And also it will be questions in there about the accused. For example, do you have anything to say about the offense? when I had clients, what I would tell them is tell them you're not going to speak about the offense on advice of your attorney. Because sometimes when defendants are not speaking about the offense, then people will say they're not remorseful. And then sometimes you would have your client who will have pled to a case and then go into the PSI and deny ever join it. And some judges, depending on the judge, will say, okay, then we're going to trial. And that opens up a whole can of worms. So I would always advise my client not to speak during the PSI, because whatever you're saying in that PSI, the state will get to see, because both sides get to review the PSI. And it may be something in there that make you look not remorseful to the judge or not accepting what you've done and learning from it. And it also has the TAP evaluation, and the TAP evaluation is really sort of a resume or CV for your drug use. So it will tell you about drug use. Oh, just 1 second. Yes. Yes, it's for compliance. So if you'll have them pull the file, we'll take it up. Awesome. Oh, no. And then he needs an interpreter or no?
No, he can handle it.
Okay.
He went to school here. He's just more comfortable in Spanish.
Okay, all right. I'll take that up in a few minutes.
Thank you.
All right, Renee Gardia. Oh, she'll come up, please.
What?
Hello. Hi, how are you doing today?
I'm hanging in there.
Okay. So has she, I know we were here for a mental health screening.
Judge, there was some challenges with Renee's phone.
Okay.
I talked to Michelle yesterday. We're going to do it at 10:30 this morning in person down on the first floor. So
okay,
we should know something was pushing out a few weeks, and we should have a status on it.
Okay, awesome. Norma, on Renee Gardia, can you give me a reset for 3 weeks? All right. So we'll be back on November 9th. And at that time, they'll let us know whether or not you've been accepted in mental health court. What will happen if you're accepted in mental health court, you will no longer be reporting to this court. You'll be reporting to mental health court. Okay. And your attorney will explain it to you. Once you sign the reset form, you're excused.
Thanks, Ron.
You're welcome. All right, if the defense and state have no objection, yes. So mental health court, it is exactly what it says is it's for people who have mental health issues. And sometimes the offenses are related to their mental health. So if there is a mental health referral and it's not a violent offense, usually they will be accepted in that court, and that court will make sure that they have a case manager. So they don't pick up any of the offenses, and it will actually address the underlying offense. So for example, this is a drug case. Usually people who have mental health issues, sometimes they use controlled substances, and you really don't know they have a mental health issue until they're completely clean and sober. Then you see what the mental health issues are. But she has documented mental health issues. So that's why she's been sent to mental health court. And so if they accept her and she completes everything successfully, this case will be dismissed. And then she'll have a case manager to help her stay, on her medication. Yeah. Yes, that's what Judge Ron Rangel. Raul Paral.
Good morning, Judge.
Good morning.
Judge, first of all, I wanted to apologize for the way I'm dressed. I was hoping to see you in the back.
No, I understand.
I'm real sorry about
You're
that.
always dressed appropriately, so.
So I'm sorry about that. Judge, on Raul, we're set for Monday on the plea deadline.
Yes.
Setting. I have a conflict on Monday. I would like to recall it for next week. If I can do Wednesday or Thursday, Judge, that would be very.
Okay, let me just check.
And we're real close to working something out on that case.
So you're asking for October 26th?
Next week, yes, ma'am. Because we're set on Monday of next week.
Yes.
So Wednesday or Thursday, Judge, would work for us.
Okay. Norma, I'm going to give you this file. Can you put it on October 26th and move it from October 23rd?
Yes, ma'am.
And it'll still be the plea deadline date. You're able to get in touch with your client?
Absolutely, Judge. All right, appreciate it.
You're welcome.
Yeah, I apologize.
Oh, no problem. Thank you. All right, Rodolfo Aceves.
Confer with the state. And then you can get Ms. Moreno, Topaz Moreno.
All right.
I think she stepped out.
She was in the wrong court. I'm trying to send her away. Oh, well.
Okay.
Okay.
Bashan,
Yes.
is this the case where they were zooming in or no?
No, Your Honor.
All right. So this is the case where we were trying to figure out the mental health issues. Who was the prosecutor who was on this?
It was a 196.
I don't remember who
It was from Integrity Special.
All right. Can you have her come down to court?
Yes.
All right.
It's
So,
gonna be a second. They're gonna have to step back.
okay, so we'll have her come down and then we'll take this matter up.
Thank you.
All right, you're welcome. Thank you for your patience. Thank you.
And he's out, Judge.
All righty.
Yeah, like he doesn't want to do anything.
And Mr. Maurer, this was a plea to one case, is that correct?
Yes, ma'am. Yeah, it's a wreck. There's just, I guess, issues as far as conditions.
Okay.
As far as I'm aware of everything, but if there's something to my attention, I'll try to find him.
Right. Court is calling 2023 CR 1475 State of Texas versus Larry Haynes. Can I have the parties approach and announce for the record for the state?
Zach done for the state, Your Honor?
Defense.
Robert Maurer for the federal law.
And are you Larry Haynes?
Yes, ma'am, Your Honor.
You entered a plea on September 8th, a no contest. You applied for probation. The state recommends probation according to the plea bargain agreement. And there are cases to be taken in consideration. Was a PSI completed on this case?
It was, Judge.
Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, we have, Judge.
All right. Any objections to the PSI report?
No, Judge, just argument.
All right. And just give me one moment. Let me pull up the PSI report. All right. The court will hear argument.
So, Judge, I reviewed the PSI and TAP with my client. The TAP I was kind of concerned about because it recommended ISF, substance abuse and cognitive track, but I didn't notice, I don't recall any issues on the PSI or on the offense involving drugs or alcohol or anything in the TAP where the client made any sort of admissions about drug or alcohol use. Okay. I was just going to ask the court, he's been incarcerated for 6 months. He and the complainant have 2 children together. He has a job waiting for him. He's going to be living with his brother. And I'd ask the court to let him do, I guess, intensive outpatient if the court does think he needs some sort of monitoring for treatment and perhaps UAs and allow him to get back to work so he can try to provide child support for his family in light of the state's recommendation.
All right, state.
Just with respect to ISF or outpatient, we just defer to the court and ask that you follow the agreement, and the state will defer to the court on that specific issue.
All right, so in the report, there's a no contact order with the complainant. So the court, it does not remove no contact orders unless the court has information from the complainant and the court is assured that the complainant is safe. So that no contact order is going to remain.
I think she noted she wanted that. I think that's part of the, she gave a statement in the PSI stating that she didn't want to come to court, but she wanted the no contact order to stay in place. So obviously if they have some sort of change in the future, he'll need to get a lawyer to approach the court about it.
Okay. And state, is the complainant aware that he is going to be released today?
Yes, Your Honor. I believe that's correct.
She noted that in the she was okay with the probation.
All right. And how old are the children?
3 and 4.
Where are you going to, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. State your name for the record.
Larry Haynes.
All right, Mr. Haynes, who are you going to be living with?
My big brother, Sherman Johnson.
Does he know you're going to be living with him?
Yes, ma'am.
Does he want you living with him?
Yes, ma'am.
Does he have any children?
No, ma'am.
Is he living by himself?
No, my sister-in-law.
Okay. Does she want you there?
Yes, ma'am.
Okay. And what employment prospects do you have?
I can go back to work at HEB warehouse on off of Riddiman Road and I-35.
Okay. And is there a child custody agreement in place?
Have you all been to court? Do you have a lawyer at the AG's office or
Oh
something?
no, we both have our rights. Both have our rights to custody and everything. So
the question is there a court order? Did y'all go to court and have a judge impose it?
All right. So you all are just dependent on each other to be fair with.
Yes, ma'am.
Okay.
Sorry.
All right. This is what the court is going to do. The court is going to sentence you to 8 years in the prison, suspended and probated for 5 years. Take in consideration the following cause numbers: 2019 CR 6035, 2022 CR 0842. There's an affirmative finding of family violence. There's to be no contact with Rowena and Suarez. I understand that you all have children together, but what you'll have to do is that will have to be arranged through a third party. You understand?
Yes, ma'am.
Of course, if something, God forbid, something were to happen and there is an emergency,
yes, ma'am,
the probation will let me know that you've had contact, but then they will tell me there was an emergency, they were at the hospital or something of that nature. But other than that, you're not to have any contact. You're not to be contacting her through third parties. Do you understand?
Yes, ma'am, I do.
There is to be 200 hours of community service restitution. I'm going to want parenting classes. Once parenting classes are completed, the court will deem that the community service hours are satisfied. Regular reporting by Zoom or in person. Regular UAs. We're going to start with outpatient treatment with probation. Probation will do field visits one time for 3 months and thereafter as probation deems necessary. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. There should be no unsupervised contact with minors until you've had at least 2 parenting classes.
Yes, ma'am.
And they're asking, and it's listed outside the plea bargain agreement, but this is an assault case. So I'm going to grant the BIPP program unless defense, you have a reason why that shouldn't be.
Judge, I don't think so. I mean, I think it's probably appropriate based on the circumstances.
All right. And the BIPP course. Probation, is there anything else he needs?
In order for me to do outpatient treatment, I need a towel.
It was completed.
Oh.
Yeah, now we'll start with regular outpatient and then we'll see what happens. All right, Mr. Haynes, is there anything else you need from the court to be successful?
No, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Okay. Because this is a felony conviction, because this is an affirmative finding of family violence, dismissal.
Yes, Judge, I have them.
You are not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Yes, ma'am.
Because this is a plea bargain agreement, and because I followed your plea bargain agreement, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. Here's the thing about relationships. If you're in a relationship where somebody started to check somebody else's phone because they don't trust them, then that means you have no trust in the relationship, and maybe that relationship should be done with.
Yes, ma'am.
When you have children, I don't know if your child is a girl or a boy.
A girl and a boy.
All right. So children learn by what they see in a household.
Yes, ma'am.
So if you have a daughter who sees their parents fighting or the father being abusive to the mother,
yes, ma'am,
that child will think, well, he loves her. That's what I'm being told. So this is the way people behave when they are in love. And she may be accepting of that in a relationship because of you.
Yes, ma'am.
When you have a son and he sees that, he will think, this is how you show love to somebody. And I don't think you want that to happen. I don't think you want anyone to be putting their hands on your daughter, right?
No, ma'am, I don't.
And I don't think you want your son to end up where you are, correct?
No, ma'am, I don't.
All right. So if there's anything with probation, you feel like they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right. Good luck. Go forth and do better.
Thank you, Judge.
Thank you so much.
You're welcome. Thank you.
Yes, ma'am. May we approach?
Just give me a moment.
You need file that?
I don't.
You should require file.
Yes,
Is
the
there
file.
a meeting announcement?
Yes, yes.
Okay.
All right. So I'll do it. We go in order of appearance.
No, I know Mr. Esparza said he was called down by
Yeah.
your courts.
Yeah,
So
yesterday you talked, you wanted me to come by today.
Yes.
Yeah, we didn't
So
know.
once I pull the file, then we'll take it up. Yes. All right. Is the prosecutor here for Rodolfo Aceves? All right. We're waiting for her, Mr. Cisneros.
Yes, ma'am. Thank you.
Aron Bawani.
Morning, Judge.
Hello.
Morning.
How are you doing this morning?
Good, and you?
Oh, I'm doing great. All right. Today is your plea deadline date. So you need to ask, let the court know whether or not you're accepting the offer from the state.
Judge, we have an offer. We believe that we're trial tracked at this point. And so but we're working to get everything from the state. They're still in the process of trying to get us everything.
All right. So Mr. Bawani, you are a U.S. citizen, correct?
Yes.
All right. I always ask that question. All right.
Yes.
State, family violence?
Yes.
Bawani, I need an acknowledgement of discovery.
Okay.
And how long do y'all expect this jury trial to last?
3 days.
All right, Ms. Ferguson, family violence, 3-day trial date.
They can go to impact judge on December 4th.
All right, so we're going to set you on December 4th. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes.
All right, so you looked like you did not understand.
Yeah, I don't understand what exactly.
Okay, so today, well, actually on September 21st, the state gave an offer to you. Do you remember what that offer was? All right, so I'm going to need you all to step back, confer with the state on the offer, then come forward.
Yeah. Oh, no.
I'm sorry?
Yeah, I remember now.
You remember the offer?
Yeah.
All right, so I reset it for today, October 19th, so you could have a chance to think about whether or not you were accepting the state's offer. So are you accepting the state's offer?
No.
All right. So your plea deadline date has expired. The court will only accept a plea bargain agreement with good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes.
All right. So what date? You said December 4th?
Yes, ma'am, and it will be in impact.
All right. So we'll be back on December 4th at 9 a.m. and you'll be going to impact court for your jury trial. Do you understand?
Yes.
So the trial will not be with me. It'll be in impact court.
Okay.
All right. Ms. Ferguson will give you a reset form, then you're excused.
Thank you.
All right. You're welcome.
Thank you, Judge.
You're welcome. Kevin Luna? Yes.
May we approach?
Yes. And you're all on this side.
Right up here, behind.
Yeah. Why do people go?
Okay, sorry.
No problem. All right. So my understanding is you've been hired?
Yes, Your Honor.
All right. Have you filed the notice of retained counsel?
Yes, Your Honor.
All right. So then you are relieved.
All right, thank you, Judge.
All right. So with regards to discovery, Mr. Esparza told me that he had handed over everything that he had to you.
Yes, Your Honor.
All right. Is there any outstanding discovery?
I don't believe so, Your Honor.
I don't know that that's quite true. Mr. Garahan, I've spoken to, and he's not here today. So I just want to talk to him about that because I do have some questions about some things in the file.
All right. So you all are going to have to confer off docket. This is an older case. What I'm going to do is I'm going to give you all one last date for discovery, and that there will be no more discovery dates. All right, Ms. Ferguson, can I have a 30-day reset on this for discovery? And this will be the final discovery date.
It'll be November 15th.
All right, November 16th.
Give me 1 second. Can we do the 27th?
Let me see.
Is that around Thanksgiving, Judge?
It's after Thanksgiving.
Oh, it's after? Okay.
Yeah, it's the immediately following
Okay.
Thanksgiving.
Okay. Yes, I can do that.
All right, we're going to come back on November 27th. At that time, that will be the last discovery date. And state, you'll need to tender an offer as well.
Yes, Judge.
And Your Honor, if I could, and I mentioned this to Mr. Garahan, there is some further work that needs to be done on behalf of Mr. Luna. I brought in a new expert, and based on some things that hadn't been looked at, we may have to come to the court and talk to the court about that, but I will talk to the court about that. I just wanted to let the court know about that.
All right. Offer needs to be tendered. This case has been on the court's docket for discovery versus with surveillance videos since August of 2022. We're about to hit a year or more on this case where there is no movement. So state, on November 27th, you need to be prepared to tender an offer, and that's going to be the final discovery date.
Yes, Judge.
All right. Is there anything else?
No, Your Honor.
All right. Thank you.
May I be excused, Judge?
Yes.
Thank you.
Juan Martinez. All right, this is a motion to revoke. And I believe this is criminal trial division.
Yes, sure.
Have you conferred with the state?
Yes, we have an offer.
Okay. And you conferred with probation?
Yes.
All right, court is calling 2020 CR 4576, State of Texas versus Juan Manuel Martinez. Can I have parties announced for the record for the state?
Laura Metzold for the state.
Defense.
Paul J. Smith for the defense.
Are you Mr. Martinez?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Juan Manuel Martinez who was placed on deferred adjudication in 2020 CR 4576 for the offense of robbery on December 16th, 2020 for a period of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 5 in Bexar County, Texas, the defendant Juan Manuel Martinez did then and there fail to report to the supervision officer as directed for the months of October, November 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
And we'll waive the remaining violations, Your Honor.
Objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, there is.
Yes.
Revocation and adjudication and sentenced to 5 years in Texas Department of Corrections.
Defense, is that the agreement?
It is, Your Honor.
Mr. Martinez, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Juan Martinez.
All right, so why didn't you report?
Because I had a DWI. I had drinking. I didn't want to get my probation revoked and have my dad work the whole summer, knowing that he needed my help. So I know that I failed to report because I didn't want to.
And when did you pick up the DWI? Is this December 26th?
Yes, Your Honor. On Christmas or Christmas night.
But then that doesn't explain why you didn't report in October, because you wouldn't have had the DWI until December.
Okay.
All right, because it's saying here that you didn't report for the months of October and November. And according to this, which I'm not saying it, taking it as true, but according to this, allegedly, the DWI case didn't come till December 2022.
Yes, Your Honor. I'm not too sure.
All right. Has he done anything on probation?
I mean, pick up number 1. So we
Yeah,
that.
I mean, yes.
Your Honor, this is his second MTR. As far as what I can tell, he has not done anything. He hasn't completed any of his community service hours. I will say he did pay $1,241 of his $7,625 assessed fees. Other than that, no, ma'am.
All right.
There was a negative UA back in December of 2022, diluted in September of 2022. There was a positive in January of 2022.
All right. And with regards to the restitution, was any ever tendered to Mr. Antunes and Miss Villalobos?
Your Honor, there isn't anything under the financial portion that indicated there was restitution, actual restitution numbers, the amount for restitution. So more than likely not.
Okay. All right. The court will find you guilty, revoke, sentence you to 5 years in the prison, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. You want to walk around?
I want to touch the microphone.
Thank you. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, You do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Mr. Martinez, how old are you?
26.
All right, you're going to have to start doing better, because otherwise you're going to find yourself in and out of somebody's jail and in and out of prison. If you have a drug or alcohol problem, I can request that you be placed in the therapeutic community. Whether they accept you or not will be completely up to them, but at least they can help you address any alcohol or substance abuse issues you have. Would you like that?
Yeah.
All right. So I'm going to add therapeutic community to his sentence. You'll still need to request it. It doesn't increase the length of time that you've been in custody. So for example, if they're going to release you in 5 years and you're still working on your substance issues, they're not going to say, oh, we're going to keep him. You understand? All right. All right. Good luck to you.
Thank you.
Miss Abrams. Oh, Mr. Aceves.
Yeah.
Yeah, because I don't see the.
They're trying to locate her.
She's here.
Oh, she's here?
She's here.
Oh, okay. Yes, on this one. Yes, on this one, this was the case where we were trying to see if there was any other mental health treatment outside of probation.
Okay. I'll double check our files to see if I have anything.
Okay, thank you. Mr. Cisneros, Ms. Abrams is going to check in her file very quickly and then we'll take it up.
Thank you, Ron.
You're welcome. Yes. Okay. All right. Awesome. Thank you. All right. So if I could see the parties on Mr. Aceves. Aceves. I keep mispronouncing his last name.
Aceves, you're saying?
Aceves. Okay.
Yes, ma'am.
All right. Thank you.
You got the hang of it here.
All right. So probation has informed me that he does have an appointment already scheduled with the Access program.
Okay.
And you're aware of that appointment date and everything?
Yes, Your Honor.
All right. So you need to make sure that you make that. And if you all will come around. And Mr. Cisneros, so you'll have that as well. If you all want to, it's from probation.
Okay.
So that will be his next date for that. So he needs to make sure you make that meeting. All right. And then once I have information back from them, then we can always come back and address the GPS issue. But I just want to make sure that you're have a case manager or have someone who's speaking to you, and then we can address the GPS issue. So the GPS most likely will not be forever or the length that you're on probation, but I just want to make sure that everything is in order. Do you understand?
Yes, Your Honor.
All right. Do you have any questions about anything?
No, she just said not until after this happens, and she talked to us about GPS. No. Okay, I was saying too. No questions. No questions.
All right. Anything from the state?
No, Your Honor.
All right. So I think this is the agreed plan now that we're at this stage where he's on probation. So it is still very important that if anything comes up, you have people that you can contact. You can contact your attorney. You can come to court. Do you understand?
Yes, Your Honor.
All right. So let's reschedule this, and I'm going to reschedule this for 45 days because then that'll give us an idea. Well, maybe 60 days.
I have a vacation letter for all of December, Your Honor.
Okay.
So, but I'll come in because I want him to get to work if we can.
Okay.
So if you want to give me a December date, that's fine.
All right. So I could do it in 60 days because that will give us an idea, and the state will have a benchmark.
Yes, ma'am.
And maybe there will be an agreement to removing or an agreement to tracking or something else.
Right. For him, I'll take any December date.
Okay. All right, Ms. Ferguson.
Yes, sir.
On this case, can we do a compliance? And let's do it late December.
The latest I can do is December 11th.
All right, so we'll come back on December 11th to see where we are.
Thank you, Your Honor.
All right, Ms. Ferguson will give you a reset form, then you all are excused.
Thank you.
Thank you.
It's 11, 68, 75, 58, 75. Yep. Probably wrong. You approach the chief. Lorraine, L-O.
Yes.
May I get a new court date on the 11th? I have a mediation and it may be in Bryan, Texas.
All right.
I can come on the 12th.
All right. If you'll talk to Ms. Ferguson about that.
Okay.
And she'll change it on the docket sheet for me.
Yes, please.
It's 16.
Thank you.
She'll bring you in.
Yeah.
Cameron Lawrence.
A person for him, Judge. He's still in federal custody. I thought he'd been brought back by now, but it appears that he is still not in Bear County.
Okay. All right, and what is the federal charge?
It was based on the same transaction. It was a felon in possession of a firearm.
Okay. So maybe that case may or may not take care of this one. We shall see. Ms. Ferguson, can you give me a 60-day reset on Cameron Lawrence?
December.
All right, we'll come back on December 11th.
Thank you, Judge.
You're welcome. So what ends up happening, sometimes you have people who have federal cases, and maybe the federal case is related to the felony case or whatever charge they have. And because the federal court takes precedent, sometimes when they take people in custody, they don't get released to us unless there's a bench warrant or something else happens. And then sometimes the state will say, well, the federal government is handling their case, so we'll just let them, whatever they decide, that's what we'll go along with. It just really depends on the case.
Nine days. All right. Positive is the fact that recently, marijuana just apparently the mother's child went to jail. She was on a certain land. Like this, so it shouldn't even have. I wait. I know some stuff share priorities. It's probably just 1 year for you to sign this form and out of it. Look at it.
I brought both. It's stop like they don't eat. Flower 15. So, no, they probably keep these.
I don't, I mean, I would not go into the child case. I can't prove the child. That's it. I think that's the way it is. I don't. That's I wouldn't go about. I think that. If the best you can do is
yes. May I approach for a second?
Yes.
This is on a
And how are you doing today?
I'm doing fine. May I approach?
Sure. All right, George Hawkins.
Yes, Your Honor, present.
All right. So where are we on this case with discovery?
Yes, Judge. I reviewed the discovery prior to court. It seems to be intact at this point. There is some mitigation that we're wanting to get over to the state of Texas. My client has been and is receiving mental health treatments, which we believe that his mental health issues more or less contributed to this case arising. So I notified the state that discovery seems to be intact, but we wanted to get them some additional information to make an offer.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Hawkins? All right, November 16th.
Yes, Your Honor.
And state at that time, I'll need you all to tender an offer in between that time, turn over whatever mitigation you have.
Yes, Your Honor.
And if you all are looking towards mental health court, then let the court know on that day.
Yes, Your
All right, once you sign the reset form, you're excused. Thanks for dressing appropriately for court.
I was about to say, Your Honor, me to share. Suit game, right? So thanks for.
You're welcome.
Judge.
Yes.
Correct real quick.
Yes.
I found the answer that you were correct. It was judge enough.
Okay.
Thank you. I appreciate
All right.
it.
Thank you. Because usually I have hearings.
Yeah, no. So that answered that. Thank you. I appreciate it.
You're welcome. Johnny Aguirre.
Yes, Your Honor. He's also my client in custody.
All right, the court is calling 2023 CR 5468, State of Texas versus Johnny Aguirre. And this is Criminal Child Division. Should have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Rene Munoz on behalf of Mr. Aguirre.
And are you Johnny Aguirre?
Yes, ma'am.
All right, you entered a plea. Let me find the docket sheet. You entered a plea on September 12th. You applied for deferred adjudication. And according to the plea bargain agreement, the state is recommending deferred adjudication. We are here because a TAP evaluation was requested. Have both parties had a chance to review the TAP evaluation?
Yes, Your Honor.
Yes, Your Honor.
Does anyone wish to speak to the TAP evaluation?
Yes, Your Honor. If I may briefly, I did speak with probation about the recommendations in the TAP. I know that DDRF is listed there for inpatient. I also know that it's approximately 6 to 13 week wait. My client has admitted to the court openly and honestly that he has issues with methamphetamine use, Judge. So we would like a request in lieu of DDRF if we can possibly consider for lifetime recovery. It is an inpatient facility where he would get drug help as well. It would be likely less of a time frame of him waiting in the jail. And we also had since the court had sent a referral for drug court. We did get a response back that he does qualify. However, unfortunately, this time there is a wait list. So I did speak with the case manager, Paul Manriquez, and he said that he would notify me and the probation officer when some space was available because they're going to have graduation coming up soon. Judge.
All right, babe. When did you speak with them? Because they recently had graduation.
I sent an email out last week and they stated that he did qualify, but they presumptively rejected him because he had not been ordered to probation formally yet.
So there were two issues, Your Honor. He was not granted probation yet, so he could not be put on the wait list. And they have not received all of the funding and everything that they need. So there is no available spots right now, even though we just had graduation. Okay. Is what they've told.
All right. So will lifetime recovery be a good fit for him?
Yes.
All right. All right. Is there anything else from either side?
Nothing from the state, Judge.
Nothing further from the bench.
All right. So, Mr. Aguirre, I'm going to follow your agreement and place you in lifetime recovery, but you're going to have to make sure that you stay on your medications.
Yes, sir.
And if there's an issue with your medication where it has a side effect of something of that nature, then you need to let your doctor know, and maybe they can give you something that doesn't have the negative side effects. You understand?
Yes, ma'am.
All right. So this is what the court will do. The court will sentence you to 5 years deferred adjudication. There's a $500 fine that will be probated. I'm going to order lifetime recovery and probation. If you could let felony drug court know that he's starting with lifetime recovery, maybe they can eventually find a place for him. Felony drug court is a great program because they will help you with any mental health issues as well as any drug issues. That's why I'm pushing for it. You understand? There will be taken in consideration County Court Cause number 703-653, 716-121, 200 hours of community service restitution, regular reporting, that's by Zoom or in person. And I know lifetime recovery does UAs. Yes. So probation, if you want to accept lifetime recovery's UAs, you can. But I'm going to order random monthly UAs. No contact. with 8923 West Military, San Antonio, Texas 78245 and 6550, Enrique M. Barrera Parkway, and that's 78201. Proof of employment, or SSI, within 60 days of release. There's to be no employment as a home health care provider or with minors. And then upon release from lifetime recovery, field visits 1 time per month for 3 months. And then as probation sees fits, and he's to be transferred from the Bexar County Jail by lifetime recovery. Probation, is there anything else he needs?
No, Your Honor.
Mr. Gary, is there anything else you need from the court?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Right to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
If at any time you feel as though probation is not communicating with you or there are some issues with lifetime, you can always let the court know. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Maybe excused?
Yes. Mr. Leon. I didn't want to mess up your first name.
No problem, ma'am.
All right, court is calling 2022 CR 9798, State of Texas versus Pio Quinto Leon. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Kim Gonzalez for defense.
All right, and are both parties ready to proceed?
Judge, actually, we're asking for a reset on the MTR. He has picked up a new case, which is the basis of the MTR. And I believe it's still sealed at this point. So the state's gonna look into that and see if we can't resolve them together.
When is that going to take place?
I've actually already placed a call, or not a call, an email to our crime victim liaison to reach out to the victim in that case. It is a new sealed case, so it's still early in our intake process, but I asked her to pull it so we can start looking at getting it resolved before if it gets another setting.
All right, Ms. Ferguson, set this for a contested hearing in 30 days, please. All right, so we'll be back on November 16th. If it's contested, it's contested. If it's not contested, then it's not contested. So if you'll sign the reset form, then you're excused.
Thank you, Judge.
You're welcome. And counsel, he was late.
I apologize, Judge. I addressed that with him and he said he just got stuck in traffic. So he knows next time he needs to be on time.
All right, thank you.
I did address that, thank you.
All right, Gracie Segunda. Yes.
I just wanted to, I already showed defense counsel. We did have the statement. I don't believe defense counsel is going to have an objection. I wanted to make sure we had that available. It wasn't included in the field side. There was difficulty contacting the field side.
Is there going to be any objection?
No objection, Your Honor. I also have a packet of 32 letters on behalf of
Objection.
I haven't seen anything.
All right, if you look, well, if you all step back, if you look at that, then I'll look at that. So. Yes.
I'm here on an MTR. It's Christopher Lemire. Defense counsel provided me a bunch of documentation that's going to take me a little bit to wade through. Okay. I was hoping we could reset it for 1 week, and I'm going to need to contact a couple of these persons.
All right, if you have them pull the file.
Yes.
Okay. Oh, the file has
Oh, look at that.
Oh, ready.
All right, is he already out here?
He's still in the back. I have not brought him out yet. Sure.
All right. Norma, on Christopher Lemire.
Yes, ma'am.
If we can reset this for next week.
Next Thursday.
Yes. All right, we'll come back on October 26th. Deputy Laura, if you could let him know, we'll bring him back on October 26th.
Can they bring him out so I can explain to them what we're doing?
Sure. All right.
Yeah.
They'll bring him out.
Thank you.
Thank you.
Thank you.
You're welcome. And if it's going to be something that I'm going to need to read as well, after you all read it, if you could hand it to me, if there's not going to be any objections.
I have no objections. You'll eventually see it.
All right. So just whenever you all finish reading.
I think it's something I'm going to kind of need to call or. I'm going to call or email the person that's in charge of their county. So a lot of this appointment times is a little bit to wait for as far as what we actually fulfill.
Okay. All right. Thank you.
Thank you, Judge.
Thank you.
So that's sectors.
Judge? Yes.
No,
Okay. So let me, if you all step back, let me read this, and then I'll be ready.
yes, Judge. Just start it like still want to do like
You all right?
Ready whenever.
Sorry about that. Since it's not fast, yes, I don't think the US is
Okay.
Oh, that's enough.
Oh, no problem. Yes. Mhm. Okay. Yes. Yes.
Okay, so you're yeah. I think you're already on the right track.
Morning. Good morning.
Man. I'm your brother.
Okay, we have to call this. No, she's as soon as she called it, she took a
What was my bottom dollar? Ladies and Peter, and that's like
All right, are the parties ready on Gracie Segunda?
Yes,
All right, the court is calling 2022 CR 10214B, State of Texas versus Gracie Segundo. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Javier Oliva and Bradley Bellis for the defendant.
Are you Gracie Segunda?
Yes, ma'am.
All right, according to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes.
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we wanted to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality, the offense date that's on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that was in the criminal history that it makes it seem as if they're two separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself that Ms. Segundo gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. It's assault SBI. It's the same offense.
Okay.
We just wanted to make sure you were aware.
All right. And the court is also in receipt of victim impact statement. And the court reviewed that without objections from the state or defense. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And the court is also in receipt of letters that defense presented on behalf of the accused. And there were no objections to the court reading those letters. Is that correct, state and defense?
No objection, state judge.
All right, so the court has reviewed all of those documents.
Your Honor, I also raised that part of the agreement of coming back today was that the misdemeanor occurred on the same day of this alleged date. Was to be taken consideration with CC County Court 4 case 69-3701.
Yes, and the court does have that as a part of the plea bargaining agreement.
And Judge, just to kind of expand on that, I believe as an additional part of the plea agreement was that she was to take responsibility for what happened as a part of the TIC.
Yes. Okay. All right. So my understanding, the complainant in this case is Rebecca Martinez?
Yes.
All right. And is that the Rebecca Martinez who's on the fourth court?
Yes, Judge.
Yes, sir.
All right.
President of the courtroom.
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that it was fair and right in this case. So no objection.
All right. So are there any witnesses that anyone wishes to present, state?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant, which the court has already noted that they've read.
Yes. Defense, any witnesses?
Your Honor, other than my plea to you and our arguments to you before considering sentencing in this matter. I will be speaking, and Ms. Segundo may say a couple of words, and Ms. Segundo's parents are present in support of her today. They can stand like Mr. Is standing here in support of her today.
All right, thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Gracie Segundo.
All right, and with regards to County Court Cause number 693-701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
We'll go ahead and proceed with a guilty plea, Your Honor.
All right. So the County Court Cause number 693-701, how do you plead to that?
Okay.
All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? All right. So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. It was an assault that occurred where the resulting assault created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that day forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Segundo, I think, has demonstrated a respect not only to others, but to life and to animals, and in her work and her career in taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think like, okay, you're not going to be subject to a conviction, but in actuality, you are subject to all the conditions and behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of, it was just something in a reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agreed to repay that. We will work hard every day to pay that back. But in this working community and in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely has nothing personal against Ms. Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
No, all right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I couldn't tell you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator. Mm-hmm. Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity, people need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit, and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight, and then you decided to get involved in that fight.
No, I went to go and try and pull my friend away, and then like I don't know, it was just a bunch of people, and somebody hit me, and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator, they were asked that there was too many in the elevator, and then people had to decide who's getting off, and they asked who she was with, another man and another person, to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck, and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's why we're here 2 years later doing that. In addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here. If you want to see it, Judge, it's public record.
I would object just because relevance.
So lawsuits and filed in the city court. That's a copy from the courthouse.
All right. Unless there are some facts that are listed in the
lawsuit, the whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, well, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will.
It does not, Judge.
All right. So
just to let you know, there is a civil suit.
All right, then the objection will be sustained.
Okay.
All right. Anything else from either side?
No, Your Honor.
No, no.
All right. I've read your letters that were presented, and it appears that, you know, other than this one incident, you're a great person. But sometimes sentencing, well, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
You were on the elevator.
Your Honor, the elevator's doors open. They entered into the elevator and they were asked, there were too many in the elevator, and the elevator operator asked people to voluntarily get off.
All right, so there were already people on the elevator. Then you got on the elevator and you were asked to get out?
Us just walked in at once.
All right. And then you were asked to leave.
They said we need people to get on.
All right, so why didn't you just get off the elevator? That's what I don't understand.
Sure. You didn't decide that.
No.
She didn't decide that. It was a person that she was with, Your Honor, who is a defendant in the case that's in another court.
So my question is though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator, they had not met maybe their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. And then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator? I'll take the stairs. I don't understand.
We had already gotten off 2 floors. So we said, like, we've been waiting, but we didn't want to be the ones to get out.
And was alcohol involved, or people just don't want to take the stairs?
After a football game, Judge.
Estate, does anybody want to, I know the complainants are here. Do they want to say anything to the court?
No, Your Honor.
Okay.
Oh, Your Honor, may I have one moment?
Yes. And then after this, we're going to take up Pete Diaz, Emmanuel Castro, Michael Martinez, Larry Berry, and Michael Moore.
Your Honor, I'm going to call case Martinez.
Okay.
Your Honor, he's not a victim in this case. Why would he come to?
I mean, we'll see what he has to say. I don't know if he's a relevant witness or not, but if he were present at the scene.
You know, I would think that the person involved is the one who's, in this case, is the one that would need to address it. He's had his day in court. He has spoken before the court. I don't see why he needs to speak in this case at sentencing.
All right. You can call your witness.
State calls David Martinez.
All right.
Your Honor.
You're welcome. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
David Martinez.
All right, state.
Mr. Martinez, from your memory, what occurred on that day?
On that day, we were in line to get into the elevator. The capacity of the elevator, of course, as I mentioned, was 18, but because of the COVID era, there was an elevator attendant there. She said only 8 could be allowed in. We were 3 couples and 2 children, which were a total of 8. As we walked in, we were already in the elevator. They decide to come in behind us. The elevator attendant told them they need to step out. It's full. They had been intoxicated. Her friend.
Objection, speculation.
Overruled.
No, they were
no. Yeah, here's the thing. Where you cannot address the attorneys. Once an objection is, no problem. Once the objection is raised, just stop speaking. I'll make a ruling on the objection. And then I'll let you know if you can continue or not, if you have a question about that. That objection will be overruled.
He came in, stood at the door, prevented the door from closing.
Objection, Your Honor. I just asked for clarification from the ones. I don't know who he is.
Which he are you speaking about, sir?
Her partner. There was 2 gentlemen, which was the initial one that started arguing with us, and her partner that she was mentioning that walked in, and they were not. We were already in the elevator already when they decided to block the door from closing. Can't recall the individual's name, but it was a younger gentleman that was with her. He proceeded to argue with the elevator attendant about, letting them in or not, that it was BS, that they cannot be let in because there was a lot of room. And she told him they had to leave. He continued to argue with her, and he said that he wanted to talk to her supervisor. And she says if that's the case, she shut off the elevator. And that's when words were back and forth. They continued berating us. She was cussing like a sailor, as well as the other ones. We kept quiet, and they started again arguing with us. We stayed in there. The kids were already getting terrified. with what was going on. They started crying and they continued with their vulgar language. And I just told them one time, you know, that's it, you know, F you. The gentleman that was with him got upset. He literally from the outside ran into the elevator, knocked us all over, and you know, assaulted all of us in there. I grabbed him and I pushed him out. It was not the individual that she says was in there. It was the other individual that was with him that probably hosted them to the game. And he and I went outside. And after that, what?
From there, sir, is that where everything happened?
Correct.
Pass it with this judge.
Any questions?
Mr. Martinez, I'll just start right from leaving the elevator. So by the time that you set foot out of the elevator, you're in the middle of a physical altercation. Is that right?
Yes, while I was on the ground.
Okay. How much were you able to perceive about what was happening around you while you were in the middle of that?
Well, I was on the ground.
So my question was, how much were you able to perceive about what was going on around you during the middle of that physical altercation?
I was not able to see when I was in the ground what was taking place after that.
Okay, and we can agree that the incident in question, the basis of this criminal case here today, is something that happened during the middle of your physical altercation, right?
While I was on the ground, yes. And then afterwards, I did get up and partially saw my wife on the ground with a bloody nose. She was in a daze, and I asked her what happened. And I told her that she got hit. She said, yeah, I got hit multiple times. And I said, well, why didn't you defend yourself? She says, I couldn't because I was being held down.
Can you say for certainty whether or not Mrs. Segundo was acting in defense of another whenever she got involved in this incident?
I'm going to object to relevance.
All right, that'll be overruled. You can answer the question if you know.
I can't say that, but you know, I can answer.
Oh, and I understand, Mr. Martinez, the want for justice on behalf of the injuries for your wife. I just want to make sure that we're also serving justice here for Mrs. Segundo today based on her amount of involvement in this incident. And
there was no, go ahead. I'm sorry.
Go ahead, please.
No, there was only two other parties involved, three parties, and the individual who was with me had already left. But it was only her left with her friend. And there was nobody else around. There was people watching, nobody was getting involved, but they were the only ones actively, physically getting involved.
But and I know we started this conversation based off what's happening when you're leaving the elevator. Prior to the altercation and leaving the elevator, would you say that in any way Mrs. Segundo was the instigator who was trying to start this situation? I have no further questions.
All right, any other questions?
Nothing from the state judge.
All right, thank you.
Thank you, sir.
All right, any other witnesses?
No, Your Honor.
All right, the court will hear final argument if there is any.
Your Honor, I think it's clear that Ms. Segundo did not start this incident, that her actions occurred outside the elevator as a result of defending another person. She doesn't deny that she struck Ms. Martinez, but this was a situation where she was struck as well. And we believe that this one incident that wasn't premeditated, it wasn't started or caused by her. You know, it reminds me of a penalty, and another individual comes in their aid, and then another flag comes up for a penalty, and they both get penalties. And most cases in sports, that's offsetting. And I think in this case, at looking at the situation, looking at history since that day, that I think it would be fair to give this single mother a chance to continue her life and being a mother and working at her employment. So not to have this crash down on her with her children, with her workplace. We can't promise that she will keep her job upon this conviction. We cannot promise that she can be able to parent her children and be the primary caretaker of her children as a result of this conviction. But we can promise that if she is given a chance, she will do everything in her power to remain on probation for 7 years, to do what's right, so not to be considered a felon in a situation that she wished never had happened. There's no ill will here. There is no desire on her part to do anything but to move on with her life and pay what's owed, the $2,500, and do what it takes to win your trust. So we're asking, Judge, that deferred adjudication be given to this woman so that she can continue to do her life and do good for her children and her work and her community.
State, any final arguments?
Your Honor, the concern from the state here is, again, the facts of the case. It's that, yes, she wasn't the instigator, but she chose to take it to this level. It was her choice to take this out on the complainant. It was her choice to get involved against the complainant and to not show restraint. It's the issue that this all started over something very trivial, that if just a little bit of patience, this would have all passed over. That moment that she decided to act how she did has affected the complainant from that day until today. And it's going to affect her past this. That's why the state is asking for probation on this case and for you to not grant her deferred adjudication.
All right. So what is the amount of restitution and who is the restitution to?
It's to Rebecca Martinez and
$2,416.29.
Wait, $2,400?
$16.29.
And also in the plea bargain agreement, it says restitution to
Jeanette Rojas.
Yes.
Your Honor, so we haven't gotten any medical or billing from there. We would ask restitution to be determined on that amount.
All right. So with regards to the restitution to Jeanette Rojas, if there's a restitution amount that's submitted to the court and you all have objections to it, we can have a restitution hearing.
Thank you.
And I'll just write in that there's to be a restitution hearing as it relates to Jeanette Rojas. And I'm assuming she's going to want to transfer to Houston?
Yes, Your Honor.
And what?
It's in Harris County.
All right, Ms. Segunda, I've listened to all arguments. I want you to know I paid very close attention to the arguments that were presented, to the witnesses, and to all of the documents that the court reviewed. I realize that sometimes when things happen, it's just a Snapchat or somebody's life, right? It doesn't mean that the person is a horrible person. And I'm sure if people could go back and change things, sometimes people are serious when they say, if I could go back and change things, I would. Maybe I never would have went to the game. I would have just let the elevator went. I would have taken the stairs. I understand that. But we can't turn back the hands of time, right? And the problem in this case, and one of the things that I'm looking at is the fact that the complainant has serious injuries. And it has nothing, my consideration on whether they're a judge or not, that's not playing any factor in my decision. If she did not have that occupation, let's just say she worked at the HEB, for example, then based upon her injuries, she wouldn't be able to work at the HEB. She wouldn't be able to stock. She wouldn't be able to stand and be a cashier. I don't know what they would have her doing at the HEB. You understand? So her injuries are very serious injuries. And I've read the report that was given to me about her injuries. And I've read the PSI report and I've read the police reports again in this case, because I always like to review things. So I understand that you're very sorry for what happened, but sometimes, yeah, it's great that you're sorry. It's great that you've internalized things, but there is still some punishment associated with it. And I understand that sometimes when people have felony convictions, they say, well, now I can't do this. I can't do that. I can't do this. But then when you look at the complainant has some lifelong issues. And that's the report that I was given and that your attorney has read. The injuries that she suffered are not going away. And from the report I read, it sounds like they're never going away. She's always going to have those injuries. And I think you know that when people have broken bones, there's a change in the weather, their bones ache. I have it with my fingers because at one point in time, all my fingers were broken on my left hand. So I know when the weather is changing, it gets a little bit painful, not unbearably painful, but it does. So those are a whole host of things that happens when somebody suffers the injuries that she suffered. I understand, as I said, that you're sympathetic, and I believe that you're sympathetic, and if you could do things over, you would. But I am where I am right now, okay? All right, this is what the court is going to do. Court will find you guilty, sentence you to 7 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated. There's a transfer to Houston, Texas, Harris County. Taking consideration County Court Cause number 693701. There's to be restitution of $2,416.29 to Rebecca Martinez. There's to be no contact with Rebecca Martinez or Jeanette Riojas. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 100 hours of community service restitution. That'll be waived once you complete parenting classes. There's to be regular reporting by Zoom or in person, regular UAs, and restitution hearing as it relates to Jeanette Riojas. I don't see this as an anger management situation. I see this as an aberration. I think she doesn't need anger management classes. So is there anyone going to object to me not giving her anger management classes?
The state won't object, Judge.
All right. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Yeah. All right. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So what I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that, and you want to argue about it, pick another day to argue about it. You understand? All right, good luck to you. Thank you. Pete Diaz.
Your Honor, may I quickly approach you?
Yes.
I don't remember what order you filled up. I have Larry right, and I keep getting on one on each set.
He's after this. So let me take up Pete Diaz, and then I'll get to you. Pete Diaz.
Yes, ma'am.
Okay. All right, thank you. Who's the attorney for Pete Diaz?
I don't see him.
All right. Mr. Diaz, if you'll have a seat. Emmanuel Castro. Who's the attorney for Emmanuel Castro? This is Criminal Trial Division.
Morning, Judge.
Good morning. Court is calling 2017 CR 4326B, State of Texas versus Emmanuel Castro. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Defense.
Stephen Hartwich for Emmanuel Castro.
Are you Mr. Castro? Okay. All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? No. Are you the same Emmanuel Castro who was placed on deferred adjudication in 2017 CR 4326B for the offense of possession of marijuana 4 ounces to 5 pounds on September 6, 2017 for a period of 4 years? Is that you? Yes, ma'am. All right, state.
Violated condition number 5. In Bexar County, Texas, the defendant, Emmanuel Castro, did then and there fail to report to the supervision officer as directed for the months of June, July, August, September, October, November, and December 2018 in violation of condition number 5.
Just one moment. I don't have that motion. Is that a supplemental?
No, it's on the, oh, sorry, it is on the supplemental, Judge. I apologize.
All right. Mr. Castro, I'm going to show you what's entitled State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney as well and understand it?
Yes, ma'am.
All right, then to violation of condition number 5, how do you plead, true or not true? State.
And then on violated condition number 5, the second one, Your Honor, in Bexar County, Texas, the defendant Emmanuel Castro did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December of 2019 in violation of condition number 5.
How do you plead to that? True or not true? I'm sorry, you need to.
And we'll waive the remaining violations, Your Honor.
All right, any objection?
No, Your Honor.
Did you understand by pleading true to violations 5 and 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to 5 and 5?
Yes, ma'am. Sorry.
Court will find 5 and 5 true. Is there a proposed agreement?
Yes, Your Honor, there is. For revocation and adjudication and to proceed forward on sentencing under 1244A for 45 days in the Bexar County Jail.
We're just going to recommend 9 days.
He says on his credit for 45 days. Give me 1 second, Your Honor, to make sure it's not my offer.
Sure. All right, so what are you?
Because his agreement on here says for 45 days. And so I'll just need to verify with him that he changed it to 9 days. Yeah, his offer is for 45 days on here. So I'll need to verify with Daniel because he didn't make any changes on here to verify that he agreed for the JSOC.
All right, so here's the question. Why should I give him 45 days or even 90 days under 1244? Has he done anything?
Judge, as a condition of his bond, you asked him to take sober
support meetings.
He did attend that. Would you like to approach, Your Honor?
Yes. Any objections to the court?
No, Your Honor. Also, Daniel Escobar from the state of Texas.
So what is the proposed agreement?
It was for 9 days in the Bexar County Jail under 1244, Judge.
9?
9. And probation was recommending judgment unsatisfied. So.
All right. And how much time does he have in?
I think 9 days.
9 days, Judge.
All right. I don't think 9 days is appropriate. So, I mean, you're going to have to go to the Bexar County Jail. You understand?
Yes, ma'am.
All right. So what I'll do is I'll grant the motion, find him guilty, and sentence him under 1244. And I'll sentence him to 30 days in the Bexar County Jail. And I'll give him credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, you have a limited right to appeal. That's as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand?
That's fine.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. So here you go.
Sorry.
No problem. Oh, you know what? Can I see that back for a moment? I think I took my docket sheet there. Larry Berry.
Morning, Judge.
Good morning. What is happening with this case?
Judge, the hang up is this. We were set for a PS holiday for sentencing.
Mm-hmm.
I've read the recent investigation report. Among other things, it's recommending that Mr. Berry go to residential treatment, a dual diagnosis.
All right, so has the PSI report been done?
Yes, I have it in front of me. The problem is, Judge, is that earlier this week on Monday, Mr. Berry, there was no bus service to wherever he had to go to have this mental health evaluation that you ordered be done. So he walked 2.5 hours, got there at 8 in the morning, was told his appointment wasn't until 12, and that the evaluator would be there the rest of the day and they would call him and tell him when to come back. He said they didn't call. The next available date, according to probation, is November the 13th.
Probation.
Yes, Your Honor. Who set that appointment?
All right, for Mr. Berry, what is happening with him?
Just as counsel was stating, Judge, we've done the PSI, we've done the TAP. The TAP recommended further investigation or further evaluations with Center for Healthcare Services. That appointment was supposed to be on Monday. There was a failure they reported a failure to report. I understand what Mr. Berry may have said. So he was not evaluated on Monday. I did reach out to them to see when the next available possible date would be, and that would be on November 14th at 2 p.m. I did stress to counsel that Mr. Berry needs to make sure that he has, arrangements, make sure he's there on time, and he does not miss this.
Do you understand?
Yes, ma'am.
If you miss that appointment, what's going to end up happening is we're going forward with this sentencing. Do you understand?
Yes, ma'am.
And a warrant may be issued for your arrest, and then they will have the appointment for you if needed at the Bexar County Jail. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, can you recall this back for November 16th?
Yes, ma'am. I already have it.
All right.
May I just check the calendar, Judge, to make sure I'm all right.
All right, they'll give you your reset form. Michael Mora. Counsel, on this one, the state's supposed to present to the court the criminal history.
And I did inform her of that.
Yeah. All right. So if you all will step back for 2 minutes and let me review that. And then Ms. Ferguson, when do you want to recall Mr. Stryjak, since his counsel is in trial in the 290th?
It'll take about 3 days.
Okay, so
You can do it next Thursday. The 26th.
all right. Yeah.
May I put you on it?
Yes. Stryker. Yes, he did. He did announce. Yes, just reset it. Zachary Guerrero. And counsel, you're on this side. free Nell. Could I have party for the defense?
Tim Molina for Mr. Guerrero.
All right, is your client ready to proceed?
Yes.
All right. Mr. Guerrero, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Your Honor, we were approaching about an announcement regarding the NTR.
Okay, that's okay. So what is happening?
As the court can tell, there's a new #1 violation allegation of aggravated robbery that was, I guess, the offense date is the end of August. The discovery is not complete. I have received what they have, but there are other items that we do need to review. And given the serious nature of his underlying offense that he's on probation for, and the fact that it's deferred, and then the allegation of the first degree in the new offense, I'm asking for a brief reset. The state has indicated they are going to reach out to SAP to have the rest of the discovery completed. We were going to ask for a 2 to 3 week reset. I would only point out that I'm pro tem on a capital that's starting November 6th. It'll be over that week. So I was going to see if we could move it to November the 13th that week to come in and hopefully try to work something out.
All right, Ms. Ferguson. On this case, can you set it for a contested? And if it ends up being a contested, it's contested. If it doesn't, then it doesn't. And can you recall it in December?
And I don't know, his aggravated robbery case has a setting on my calendar, I think next week.
We'll move both of those.
But I don't know if the court does.
We don't do night mags unless defense counsel requests it.
Okay.
All right, we're going to come back on December 7th for a contested.
Okay, thank you.
You're welcome. And counsel, if you want it sooner than that, then he can be brought back sooner.
Okay, thank you.
You're welcome. Christian Smith. All right, where are we on the PTD?
Good morning, Your Honor. Mr. Smith had a little family issue going on, so he hasn't completed the classes he needs to get a dismissal for PDV. So we're just going to ask for one more reset so he can be able to complete his classes.
All right, Ms. Ferguson, can I have a reset for PTD on Mr. Smith?
You can come back on November 14th.
All right, we're going to set you for November. Yes.
I will be out of state on November 14th, and I don't want to.
All right, well,
that whole week I'm out of state.
Okay, then he can come back on the 9th.
All right, November 9th.
November 9th. Sounds good.
All right, thank you.
Thank you. Have a seat.
Judge Steve on page 8.
Thank you. Pete GS. And then Ms. Kramer, your case will be next. Good morning. All right, are you all ready to proceed?
Yes, Your Honor.
All right, I need a trial court certification. I don't have one.
But we keep going to be continued.
Not unless I say so.
I mean, that's if the court decides not to do the agreement, then I can do one then. But I can do it now.
All right, thank you. If you could, please. Oh, it's on the wall, Mr. Cox.
2021 DR 2125D.
Thank you. All right, court is calling 2021 CR 2125D, State of Texas versus Pete Diaz. Can I have the parties announced for the record for the state?
Chandler Bowen for the state of Texas.
Defense.
Cornelius Cox for the defendant.
And are you Mr. Diaz?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Pete Diaz who was placed on deferred adjudication in 2021 CR 2125D for the offense of theft $30,000 to $150,000 on September 29, 2021 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
We're proceeding on a violated condition 8B. On or about the 31st day of July 2023 in Bexar County, Texas, the defendant Pete Diaz did then and there fail to report to the supervision officer on the next working day after being released from jail for a new arrest in violation of condition 8B.
How do you plead to that? True or not true?
True.
We'll waive the remaining allegations in the motion, Your Honor.
Okay.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
No.
Knowing that, do you still wish to plead true to violation of condition number 8B?
Yes, ma'am.
Court will find violation of condition 8B true. Is there a proposed agreement?
There is an agreement, Your Honor, subject to the court's approval. That is to deny the MTR, continue him on supervision with amended conditions, specifically to include the Batter's Intervention and Prevention Program, to continue his compliance with the San Antonio Fatherhood Program, to impose a no contact order with Jessica Contreras, to have the defendant enroll in intensive outpatient treatment, weekly UAs until he's testing clean, and then back to regularly or randomly scheduled UAs.
That's right.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Yes.
All right, so what drug would you be positive for? That they're saying they're trying to wait till it gets out of your system.
They say it was meth and opioids.
Mm-hmm.
I haven't used any, at that time, everybody at the work was getting sick, and I worked with a bunch of seniors. They had gave me different kinds of meds. I took it, but I understand that I shouldn't be taking anything, but I took they're all retired nurses, surgeon nurses, and
So you're just saying they just gave you free medication.
They saw me sick. I'm the maintenance man for them, and they're trying to, I guess, make me feel better. I should have just gone to the doctor and took some medications from there. I was taking all kinds of, my boss came out positive for COVID.
And who is Jessica Contreras?
She's my baby mother.
You mean the mother of your child?
Yes, two. We're no longer together. She's moved toward Tyler.
So she's in a different city?
Yes, ma'am.
And what is happening with this new number 1?
It's going to be rejected, Your Honor, as part of this agreement.
Okay. All right, court will deny the motion, alter and amend conditions. To include the BIP course. Parenting classes. Is that covered on the San Antonio Fatherhood Program?
I believe it's a similar program, Your Honor.
All right, probation, if the San Antonio Fatherhood Program is similar to the parenting classes, then the court will accept that. The BIP course, no contact with Jessica Contreras. So for any visitation, you'll have to do that through a third party. Do you understand?
Yes, ma'am.
Yes. So who is the probation officer for Mr. Diaz? All right, if you'll come forward, please. All right. So, Ms. Martinez, with regards to Mr. Diaz, they're recommending the BIPP course, San Antonio Fatherhood Program, no contact with Jessica Contreras, and intensive outpatient treatment with weekly UAs. Is there anything else you think he may need, or have there been any other issues with him?
No, ma'am, that's fine.
Okay. All right, and so what we'll do is we'll do the intensive. I'm really torn on asking for intensive outpatient treatment because he's saying that the reason he tested positive is for medication that he was given where he works.
Yes, that's what he told me.
So have there been any other positives with him?
No, Your Honor, but we did get it confirmed and with the lab, and it did test positive for methamphetamine.
Well, is that from a medication?
It didn't say, it just said it was positive for meth.
All right, this is what I'm going to do. Do you have a drug problem, Mr. Diaz? We're going to do UAs, and we're going to do weekly UAs, or either you can do the patch. And then once he tests negative, we're going to start with random UAs. And if there's a positive UA, then we'll see where we are. So there will be weekly UAs until a negative test is presented. And once it's negative, and can you test for levels to make sure things are not going up?
I believe it's only for marijuana. We test the levels.
Okay. Well, here's the thing. This meth should not be in your system after this week. Do you understand?
Yes, ma'am.
All right, so we'll do weekly UAs until he's negative. So I'm going to want him tested every week. And then thereafter, it will be random UAs.
Can we do the IVR for the random?
Yes. So it'll be the hotline for the random UAs. Do you understand? Is there anything else you need from the court to be successful?
No, ma'am.
Is there anything else he needs?
No, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Yes.
Can I just verify, you said we were not going to go with the intensive outpatient treatment?
No.
Okay.
There you go. Thank you. All right, and then we're ready on Michael Mora. And after Michael, yes, sure. After Michael Mora, it's going to be Leonard Johnson, Michael Martinez, Christian Smith, and Darianne De La Rosa. Thanks for your patience.
Thank you, Judge.
Okay. All right, court is calling 2023 CR 4008, State of Texas versus Michael Joseph Moore. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Suzanne Kramer for Mr. Moore.
And are you Michael Joseph Moore?
Yes, Your Honor.
All right, you entered a plea in this case on October 5th to count 1 of no contest. The state waived count 2. The court found that there was sufficient evidence to find you guilty. The state was silent on your application for community supervision. Because there is such a length of time for PSIs, the court just ordered your criminal history, and the court will use that as a basis on whether or not to grant your application. The state is silent. Anything you wish to say on behalf of your client?
Yes, Judge, just a few things. While on bond, I don't really remember what got us in front of you, but we were in front of you on something And you had just given a recommendation to Mr. Mora that he might, while on bond, seek some treatment for himself, which he did do. He started going to Lifetime and has got with a counselor named Peggy McIntyre. And in fact, he was going to go into the inpatient section of Lifetime, but he got arrested. And I'll just remind the judge, it wasn't for anything other than Mark Garcia with A Action or Cowboy. I can't remember which particular bond company you were with, Cowboy. Although I had been here earlier that morning, he came in knowing I was here after I left and asked Judge Harrell to increase the bond because Mr. Moore apparently missed a check-in. So that's what got him back in custody and unable to participate in the inpatient program at Lifetime. But I also wanted him to because it sounds much better coming from him when he talks about how he was so upset about going to jail because he really wanted to get this help. He had no court order requiring to do it. He did it all on his own. If you would like to hear from Mr. Moore, he can speak with you.
Sure. If you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Michael Mora.
All right.
And Michael, I had talked to you about you will be allowed to speak with the judge about your desires to seek help and why you went and got it, even though you weren't court ordered to do so. Did you let her know a little bit about that?
I just my counselor has just told me how would you feel getting impatient, and I told her yes, I'll do it. You know, I do it just, you know what I mean, just to get the help. And after I got enrolled, I started, my drug tests started coming out clean. I started coming out, you know what I mean, negative on my UA. So I felt like it was a good help and it was helping me.
Okay. So, I mean, I'm not sure that he's ever really had any kind of help before. I'm not sure that he's ever before. He's getting a little bit older now, had the desire to seek help, but he did it on his own. You did not court order him. I do not believe to do it as a condition of bond. And I think that speaks very well for his incentive to do well on this probation, if you so grant it.
Yeah, I don't have. All right, thank you. Just 1 second. I'm being told that you pled to 2 cases and I only have 1.
Oh, you know what? It was like 4,008 and yeah.
Yeah, 4,008 and 3876, Your Honor.
Okay. All right, so they're going to give that file to me. All right. So we're back on the record, and we're also on the record in 2023 CR 3876. Is that correct from both sides? All right, and that's an evading case. All right, State, I know you're silent, but are there any fact issues you wish to bring to the court's attention?
No, Your Honor.
All right, Mr. Mora, people say all the time that probation in this court is hard. And I guess it is, but I'm trying to do things to help people rehabilitate themselves so they will not be back in front of me again or in front of another court again. So you have a choice. I can grant your application for probation, or either I can sentence you to 5 years in prison on each of the cases. Which would you prefer?
Probation.
Okay. All right, this is what the court is going to do in each case. And the court will note the evading arrest and detention was evading an arrest on a bicycle.
Yes.
All right. So just one moment. Just one moment. Just a correction for the record. The case involving the drug case was on a bicycle. The other evading was in a vehicle. All right, in each cause number, the court will sentence you to 5 years in the prison, suspended and probated for 7 years. Each case will run concurrently. And it will also run concurrent with 701883. Take in consideration 2023 CR 4009 and 689573. You're to forfeit any weapons. All right, do you have any children? You need to answer.
No, Your Honor.
All right. You're going to be inpatient treatment with lifetime recovery. And that's to be transferred by lifetime recovery. So once they pick you up, you'll be allowed to go. We're going to start off with GPS. And that'll be GPS for, let's do 4 months.
Will that be full or partial, Judge?
We're going to start off with full because he should be in his recovery at lifetime. Okay. And if lifetime feels that it's time for him to start working, they can approach the court.
Thank you, Judge.
And I'll ask that the fees are waived or deferred. There is to be the UA hotline and probation. I'm sure lifetime recovery is doing their drug testing as well. If you want to accept their drug testing for that, you can. Proof of employment within 90 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And field visits 1 time per month until further notice. And probation, with regards to field visits, if you all know that he's at lifetime recovery, you can just call or either accept the fact that he's at lifetime recovery. Probation, is there anything else he needs?
No, Your Honor. Are you regular recording via Zoom or in person?
Yes. All right, is there anything else you need from the court to be successful?
No, Your Honor.
Oh, and State, you can continue to confer.
Thank you.
You're welcome. And each cause number, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because there's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Mora, this is your chance to get your life together. I will tell you, anytime you use drugs, you never know if that's going to be your last time to use. And if you are providing drugs to other people, that's not good either, because you're building your happiness of somebody else's misery. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge. Maybe be excused.
Yes. And state, I don't know if I have the dismissals for those cause numbers.
I'll get on that then.
Thank you. Leonard Johnson. Hello, Mr. Cox. See, when you start wearing the mask, I'm thinking I'm not being careful enough.
Things out here that trying to evade you.
Yeah. All right, what is happening in this case?
I think the first setting, Judge, I just need some time to get the discovery and you just need a reset date.
All right, Ms. Ferguson, on Leonard Johnson, if I can have a 30-day reset for discovery. Ah, well, let me give you a date.
Here she is.
I need a 30-day reset for discovery on Leonard Johnson.
The 16th.
All right, we'll be back on November 16th.
That's fine, good.
All right, thank you. Christian Smith. And then after that, it's Michael Martinez. I have to give probation a break.
Well, this is not a probation case.
Ah, okay, then you're next. Christian Smith.
Judge, I think we did that one already, didn't we?
Did we?
Yeah, ma'am.
All right, I don't know why I had it again. All right, Michael Martinez. Well, there is a motion to revoke on it.
Yeah, but it's Geraldine.
See, it's with probation. See, I try to give them a break, but we'll start with the plea case. Court is calling 2023 CR 4064, State of Texas versus Michael Martinez. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Albert Chitis for Mr. Martinez.
And are you Michael Martinez?
Yes, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the lesser included assault bodily injury family.
Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Do you understand the state is proceeding on the lesser included offense of assault bodily injury family as a Class A misdemeanor? Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, on both.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 24 days in the Bexar County Jail. There are no applications. There's an affirmative finding of family violence. And if the court follows this agreement, it's the court's understanding that the judgment will be satisfied. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, sir.
Did you understand that to be the entirety of your plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
All right.
Yes,
Did you understand that by signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the less included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offer states Exhibit 1 and all attachments.
No objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
We are, yeah.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We have a deal for time with the state, and I just want to make sure my client gets full credit for all the time that he's been in county. He's got 255 days here in Bexar County. But in addition to that, he's got 139 days out of Hidalgo County. He was held on at the request of Bexar County. And so he sat 139 in Hidalgo. Then he came here he sat in Hidalgo from June 2nd, 2023 through September 25th, 2023. Then he was booked here and he spent an additional 255 days awaiting trial.
Okay.
Or I should say awaiting the MTR.
All right. And state, have you spoke to the complainant?
We have, Your Honor.
And is she aware of this?
The complainant is not cooperative with our office.
And she did submit an affidavit requesting that he not be prosecuted.
Okay. Anything you wish to say, Mr. Martinez?
Just trying to consider the time that I've already served, in addition to what I owe still on the.
All right, court is going to find you guilty. There's an affirmative finding of family violence, 24 days in the Bexar County Jail, give you credit for time served. There's to be no contact with Christina Regalado, 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 and the court will find that the judgment is satisfied. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it? Yes. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we're going to move on to cause number 2020 CR 10481W, State of Texas versus Michael Benjamin Martinez, showing you what's entitled motion to revoke community supervision and state's motion to supplement pending motion, and state's motion to supplement motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Sure.
Are you the same Michael Benjamin Martinez who was placed on community supervision in 2020 CR 10481W for the offense of assault of a public servant, bodily injury on October 29, 2020 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, there's an agreement between state and defense.
What allegation are you all moving on?
Violation number 7. On or about the second day of June 2023 in Bexar County, Texas, the defendant, Michael Benjamin Martinez, departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True.
Other allegations, are you waiving those?
We're waiving and abandoning the others, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, and sentence you to 5 years in the prison? Were you aware of that?
It's 5 over 5, but we agreed to 4.
No, I'm just.
Oh, sorry, I don't know.
Did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, sentence you to 5 years in prison? Did you understand that? And up to a $1,500 fine. Knowing that, do you still wish to plead true to violation of condition number 5? Court will find, knowing that, do you wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
There is, Your Honor.
Yes.
For 4 years, Your Honor.
What are you asking for?
We're asking for 4 years to do, as opposed to the 5 underlying sentence.
And that is the case that he actually has the 255 days of credit here in Bexar County and the additional 139 days out of Hidalgo County for a total of 394 days credit.
All right. Was there any restitution in this case?
No, Your Honor.
Okay. All right, then the court will grant the motion and revoke. Are you asking the court to follow the agreement that's been reached?
Oh, yes, ma'am, please.
Are you waiving your right to appeal?
Yes, ma'am. Yes, Your Honor.
All right, the court will grant the motion, revoke, sentence you to 4 years in the prison, give you credit for any time served in Hidalgo County and Bexar County. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes, ma'am. And you also are not allowed to own or possess any weapons due to your affirmative finding of family violence as well. Do you understand?
Sure.
All right, we can go off the record. You're going to have to do better with your life. You understand?
Yes, ma'am.
And when things are not working out with you with your significant other, you need to just leave. You understand?
Yes, ma'am.
All right, good luck to you.
Judge, I did want to just revisit one thing about the judgment satisfied case. I think you said no contact with Ms. Regalado.
Yes.
In her affidavit, she specifically asked that there be, I think she was under the impression there was a no contact order and she wanted it removed. So if we could have maybe no harmful or injurious contact.
I understand
like,
that you.
My common-law wife, like we've nothing's etched in stone with between me and her, obviously, because the whole deal. I understand the severity of everything. You know, the family violence is not to be played with. She's thought long and hard about opportunity with me, you know, and giving me a chance, you know, and deciding, you know, what we should do with the relationship, and we're deciding to work, you know, all this out. But she is in agreement with she really wanted me back on probation, but at the time is I understand, and I have to do the time, you know. We're just trying to work and fix all this. It would just be very strangeful if I couldn't do that. I'm gonna go to prison, so there's no way I'll be able to, you know, go to her house and like do something, you know, evil or whatever like that, whatever the deal is. But we're just trying to, like, you know, like being able to reconcile and do all this, like contact would really be necessary for that. You know, I go about and take all the classes that I can, you know, and you know, that's what she wants me to do.
Can I see the file on the family violence case, please? I'll allow you to have phone contact with her. That's it.
And she did write on her affidavit, you know.
No, I understand about that, Mr. Martinez, but here's the thing. I mean, you love her, right? She had bruising in the eye. And then I read the report. The report is not good. And I understand that tempers run high, people get in an argument, and then after tempers settle down, you know what the cycle is? Person will file an affidavit of non-prosecution, and sometimes cases will get dismissed because the complainant can't be found, and they found an affidavit. They've signed an affidavit of non-prosecution. Then you know what ends up happening? We have another assault case, and we come back here. Maybe somebody ends up dead, and then guess what people say? Judge, it's your fault. State, it's your fault. Defense, it's your fault. Why didn't we do anything? So the person I have standing before me right now, you have not taken any classes, right? Have you taken any family violence classes?
Yes, Your Honor. When I was on probation.
No, I mean, not just now. I mean,
recent, like
yes.
Trying to. I am in line to get in anger management and family violence there at the jail. I volunteered for that myself. It's just that they told me on my kiosk, which I know there's records of that since day one that I got to Bexar County, and Hidalgo County didn't offer any of that. Like they didn't even have church there.
All right.
Out there, you know, so or else I would have gladly, you know, and that's one of the things.
What I'll tell you is I will allow phone contact only, because I'm sure she's probably going to want to put money on your commissary books, but there's to be no in-person contact. You understand?
Yes,
and the phone contact, I'm just allowing it for her, not for you. And I say that because I know she wants to have contact with you. So yes, you will still be able to call her from the Bexar County Jail. She will probably accept your collect call. You probably shouldn't call a lot because that call costs a lot. I'm sure you're going to call her from the prison and she's going to want to accept your call. But I am ordering that there's to be no in-person contact with her. You can only have phone contact with her. You understand?
Yes, sir.
All right. Good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Darian De La Rosa. Hello. Hi. Are you all ready to proceed on this?
Yes, Judge.
All right, court is calling 2023 CR 4230, State of Texas versus Darian Renee De La Rosa. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Chair of the show for Mr. De La Rosa.
All right, and are you Ms. De La Rosa?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, sir.
Are you the same Darianne Renee De La Rosa who was placed on deferred adjudication in 2023 CR 4230 for the offense of robbery on July 17, 2023 for a period of 5 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 2, on or about the 9th day of September 2023 in Bexar County, Texas, the defendant, Darianne Renee De La Rosa, did then and there admit to using an illegal substance, namely marijuana, in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Judge. The proposed agreement is for her to go to the DDRF program.
That is correct, Your Honor.
All right, and you're aware of the wait time for DDRF?
Yes, Your Honor.
All right, and I see, even though I'm not going to consider it, there are other allegations in the motion with regards to drug use. So what are we thinking the issue is? Is it mental health?
I think she just goes out and the community judge and hangs on for one individuals.
All right, so why are we saying DDRF instead of her going to drug rehab somewhere?
I mean, my understanding was that it was mental health plus drug issues, which DDRF will be able to address.
Okay. Probation? Miss De La Rosa, you guys are recommending DDRF?
Your Honor, that recommendation came from Judge Flynn.
Okay, all righty. Then we'll do DDRF. And then after she completes that, see if they'll accept her back in felony drug court.
Yes, Your Honor.
So the court will deny the motion, alternate main conditions to include DDRF and a referral back to felony drug court after completion of DDRF. Is there anything else?
No, Your Honor.
All right, we can go off the record. Ms. De La Rosa, you're looking at 20 years in prison. Do you understand?
Yes, sir.
And when your counsel tells me the problem is you're hanging out with the wrong people, you know what those people would tell me? That they're hanging out with the wrong people. And I'll say, who is that? And they'll tell me it's you. You're going to have to get your life together. This is serious. You understand?
Yes, sir.
All right. Good luck to you. You're welcome. Michaela Johnson. Yes.
Judge, her mom's present. May she come up as well?
Sure.
She'd like to address that with the court for reinstatement. And then we're at a plea deadline, and I'd like to ask for an extension on that. May I approach with the documents, Your Honor?
All right, so let's address the case first. What is the reason for discovery? I mean, for extension of plea?
Judge, I think we're here at the plea deadline date. The state has made an offer and they've invited a counter. So since that offer, we've been working with a counselor. Miss Johnson is 17 years old, and we're working with a counselor to see if there's some mitigation that we can present to the state. So she got picked up last week, and kind of threw a wrench in our plan to get together with the counselor. So I just asked for 30 days to come back, and in the meantime, I'll talk to the state about a counter offer. She's 17 years old, serious charges, and we're just trying to work out the best possible thing we can. So that's where I'm at on that.
All right, Ms. Ferguson.
Yes, sir.
And this will be the last extension for a plea deadline day.
Very well, Judge.
Can I have a 30-day reset on Michaela Johnson.
Judge, can I throw in? I'll be out Thanksgiving week, so.
Oh, as will we.
Hmm?
We
Yeah,
will
okay.
as well.
Well,
I always try to give the staff extra vacation during the holiday times.
16th of November.
All right, November 16th.
Thank you for that, Judge. And Judge, may we address the bond violation?
Yeah, just one moment. All right, so now the violation.
Judge, I'm trying to understand it. We got notice of it, and I think it went to Judge Angelini, and he remanded Michaela without bond, and she was picked up. So she was, as a result of this case, she was placed in alternative school through the Northeast School District. She goes to Roosevelt, and she was attending some school on Saturday. She completed her alternative school, but was headed to her course on Saturday when she was notified that she did not have to go to school on Saturday.
And here they're complaining about a McDonald's.
Right. So Michaela can answer your direct questions, Judge, but in a nutshell, she thought she could use the time to go pick up food for her brothers and sisters through her father.
All right, and then what is this with Montage Apartments and Marshall's Meadows apartment?
Yes, ma'am. So the
I'm gonna have to put you on there. Oh, State, are you prepared to proceed on this?
Yes, Your Honor.
You have, you're asking that she remain remanded, or you all have discussed it?
So we discussed it. I think the state wanted to hear from her specifically as to what happened. And ultimately, I think we were going to be in agreement to allow her back on bond with the understanding that she's not to do these things. But we wanted to make sure this is actually what happened.
All right, can you raise your right hand? You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michaela Johnson.
All right, and just one moment. I know Judge Angelini has already ruled upon it for either. Oh, you know what, actually.
I printed those out for you, Judge.
Thank you. All right. To Mr. Hancock. All right, does anybody have any questions?
I'll ask Michaela a few questions if I may. Michaela, you've had a chance to read the violation report. You've explained it to me. I think there's some specific addresses that the judge was going to inquire about. So why don't you just explain to the judge what your decision was once you found out you did not have to attend school?
Yes, sir. Once I found that I didn't have to attend school, I had got a call from my little brother and little sister that they were hungry, and I thought I could use the time. So I went to the apartments to grab money from my aunt. And on the way back, I went to the apartments to ask them what they were like from McDonald's, which is why I was at the McDonald's. And I went back. My Uber took a little longer than expected, which is why I was late home.
Okay. Any questions?
No, Your Honor.
All right. Did her mom want to say anything to
No,
this?
Judge, I think we've addressed it. I just wanted you to know she has the support of her mom and is residing with her mom.
All right. And Stace?
So, Judge, I understand what happened in the violation report. It does seem like her story did make sense. That's why I wanted to make sure that the court was able to hear and make a decision based off of what happened. The state's primary concern, again, we heard all this through her attorney, but it's something that I just wanted to make sure, was this the actual thing that occurred? Also to make sure that the court admonished her and made sure that this didn't happen again.
All right. So you're 17.
Yes, ma'am.
You have to realize when you're on GPS, you're only allowed to do what you're allowed to do.
Yes, ma'am, and I apologize.
So the proper thing to have done would have been to pick up the phone, call your pretrial services officer and say, I don't have school today. I just got a phone call from my siblings. They're hungry. May I go to McDonald's? And guess what? They're either going to say yes or no. When you're on GPS, it is not best to ask for forgiveness than permission. When you're on paper, everything is, you got to ask for permission, not forgiveness. Because I think the previous judge taught you that asking for forgiveness after not asking for permission does not work in court. Do you understand that?
Yes, ma'am.
Judge, I think her mom had called Mitchell bail bonds and they would agree to get back on the original bonds if the court would consider that.
All right, if you will call Mitchell bail bonds, because I can't reinstate the bond unless Mitchell bail bonds tells the court they're okay with the court reinstating the bond. So if you get in touch with them today, what I will do is I'll ask that the bond will be reinstated and you have your previous GPS conditions and you're only allowed to go to school.
Yes, ma'am.
You understand?
Yes, ma'am.
All right. So that's not going to happen until I get notification from your counsel that Mitchell is willing to go back on your bond.
Yes, ma'am.
Can I firm that in, Judge?
Yeah, if you want to call them now, you can.
I'll do that.
You're an officer of the court.
All right.
All right, thank you.
Thank you, Judge.
You're welcome. Yes. For hers. Oh, and sorry, it's 2023 CR 3848, 3849, and 3850. Jeremy Alvarez Perez. And Deputy Laura, what I have up here is what I have. And so the only files I have left are Jose Sanchez, Aiden Garcia, Oscar Martinez, and Jose Perez. And that's it. All right, are you all ready to proceed?
Fence is ready, Your Honor.
Okay. All right, court is calling 2022 CR 8631, State of Texas versus Jeremy Alvarez Perez. Can our parties announce for the record for the state?
Travis Banks for the state of Texas.
Defense.
Andrew Priest for the defense.
Are you Jeremy Alvarez Perez?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Jeremy Alvarez Perez who was placed on deferred adjudication in 2022 CR 8631 for the offense of aggravated assault with a deadly weapon on November 29, 2022 for a period of 7 years? Is that you?
Yes, ma'am.
All right, I'm going to need you to speak up, okay?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Jeremy Alvarez Perez, did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True. And the state will waive and abandon the other allegations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, yes, ma'am.
Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor, the agreement subject to the court's approval is that the conditions be altered to deny the motion and alter and amend the conditions for state ISF, the cognitive track.
Is that the agreement?
That was our agreement, Your Honor.
All right, Mr. Alvarez Perez. I will give you a choice. Sometimes I can't give people choices. It seems that you're not doing well on probation. So I can give you state ISF. Once you complete state ISF, you will still be on probation, or I can revoke you and I will sentence you to 4 years in the prison.
Your Honor. I'll take the ISF.
All right, so from here on out, if I follow this agreement, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, ma'am.
All right, do you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Jeremy Alvarez.
All right, why are you not doing well on probation? What's going on?
It's just when they switched my probation officer, I tried getting a hold of them, but I couldn't get through, so I just left it like that.
See, there's no excuse for that because I tell everyone who comes in here that if there's an issue with probation and you feel like you can't get in touch with them or they're not addressing your issue, you can always come back to court and talk to me. And if what you were saying was true, all you had to do was come back to court. I would have been here, probation would have been here, and you would have said, oh, I can't get in touch with my officer. And I would have said, oh, let's see if we can get in touch with them now. Do you understand?
Yes, ma'am.
Probation. Is there anything he needs other than cognitive?
No, Your Honor, I think we really don't have a lot to go on since he did abscond. So we don't have any real back, anything there to give you, Judge. So I think if we start with state ISF cognitive, I think we'd be okay.
All right, the court is going to deny the motion to alter and amend conditions to include state ISF cognitive. And upon release, I'm going to want GPS, waive fees, and he's allowed to work. So it'll be partial for work only. And that GPS will be until further notice. All right. Is there anything else you need from the court?
Not from the defense.
Now, let me explain something to you. If there's an issue with probation and you feel like they're not addressing it, you can always come to the court. You understand?
Yes, ma'am.
All right, good luck to you. All right, Norma, what date do you want to bring Jose Sanchez back?
Contact me, Judge, after the.
All right, Deputy Laura, can you let Mr. Sanchez know there is a medical emergency with his attorney, and we'll let him know what his reset is.
Maybe he wants me to bring it back.
All right, Mr. Sanchez, if you'll come down, please. We'll put it for December 7th.
And then I'll bring it back to my.
All right, Mr. Sanchez, your attorney has a medical emergency. So we're going to reset you for December 7th. Yes, but if everything works out sooner than that, we'll bring you back sooner than that, okay?
Okay, thank you.
All right, thank you. Yes.
Your Honor, I spoke with the bond company. They will get back on the bonds. I think they filed an affidavit to restore on one of the cases. If they haven't done it on the other two, they will.
Okay. All right, thank you. I'll reinstate the bond.
Thank you, Judge. Appreciate it.
Okay. Aiden Garcia.
Ready, Ryan?
Thank you.
How are you doing, Judge?
Oh, I'm doing great. All right, I don't have a trial court certification.
We were going to ask for a continuance, Your Honor. We do have an offer. The reason for the continuance is he's going to get an immigration attorney because he's not a citizen. He wants to go over the offer and further. He picked up a new number 1 in Atascosa. So I'm filing my appearance today in Jordanton and trying to get all the evidence.
All right, and does he need an interpreter or no?
No, Your Honor. He speaks.
All right. Ms. Ferguson.
Yes, ma'am.
And you all are taking care of the immigration attorney?
I asked him today, he's hiring an immigration attorney.
Have you hired one?
Not yet, Your Honor.
When is this going to happen?
I'm going to go today and try to hire one.
All right, Ms. Ferguson.
Yes, ma'am.
Reset this for contested in December.
The 7th?
All right, we're coming back on December 7th, and this case is going to move forward.
Okay, and we're going to most likely reach an agreement. I don't know, you said it was contested. I don't know if that matters.
Well, I mean, it's contested, but if it turns out it's not contested, then it's not contested.
Thank you, Judge.
All right, you're welcome. Ms. Ferguson will give you a reset form, then you excuse.
Okay.
Oscar Martinez. No. So where are we?
Judge, this is where we're at. I've been conferring with Mr. Garahan regarding this case. He's not here today. Talked to Mr. Escobar. Discovery wise, we're fine. It's just a matter of us conferring about an offer. A state may come back and tell me, no chance, we're not gonna listen to my counter offer whatsoever. But I know there's discussion still going on. So whatever the court wants to do at this point, I don't know if you want to set it for one more pre-trial before we set it for trial or.
All right, Mr. Escobar.
Yes, ma'am.
Well, when will Mr. Garahan be back?
He'll be back tomorrow.
All right, we can recall it for next week. If that is good for you, counsel.
Yeah, always good, Judge, whatever you like.
So what's a good date for you next week?
About Thursday, October 26th.
All right, Ms. Ferguson, can we bring back Mr. Martinez on October 26th? All right, we'll recall you back on October 26th. Okay.
Thank you, Judge.
All right, thank you.
Judge, may I approach?
Yes.
Opt out.
Oh, sure. Just give me a second. Jared Pena. Oh, this is the same one. What day did we bring that back, Norma, for the attorney?
Yes.
All right, we're going to reset your case. Your attorney is out with a medical emergency, okay?
Okay.
Well, no, put it on the same day we did before. This is the one with the.
No, this is the different attorney.
Well, why do I have this?
That was it.
Okay, what date do you want to bring it back?
I can do that one on the 27th.
Okay.
The other one with Mr. Baker. This is Mr. Ron Ross.
Ah, okay. And you say the 27th?
The 27th.
All right, we're going to bring you back on the 27th. Once you sign the reset form, you'll be excused, okay? Thank you. Jose Perez.
Your Honor.
Oh, thank you. Hello, Mr. Perez. Are you all prepared to proceed or no?
We are, Your Honor. It's a motion to revoke. We have an agreement.
Okay, Mr. De Leon, I need a trial court certification.
I'll get that for you, Judge.
Okay. Norma, do you have a highlighter? Yes. Yes. Thank you. Yeah.
Did you have that form for you?
All right, thank you. All right, thanks. All right, court is calling 2020 CR 11096, State of Texas versus Joe Perez III. Can I have parties announced for the record for the state?
Laura Metzel for the state.
Defense.
Michael DeLeon for Mr. Perez.
And are you Mr. Perez?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Jose Perez III who was placed on deferred adjudication in 2020 CR 11096 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on July 20th, 2021 for a term of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Your Honor, on the first amended motion to adjudicate probation, violation condition number 1, on or about the 7th day of September, 2023 in Bexar County, Texas, the defendant Jose Perez III committed the offense of possession of controlled substance in violation of condition number 1.
All right, how do you plead to that? True or not true?
True.
And then violated condition number 1, on or about the 8th day of September, 2023 in Bexar County, Texas, the defendant Jose Perez committed the offense of possession of controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
True.
And will waive the remaining violations, Your Honor.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes.
Court will find violation of condition 1 and 1 true. Is there a proposed agreement?
Yes, Your Honor, to alter and amend the conditions of probation with referral to drug court with SATF followed up with SATF aftercare, biweekly UAs, sober support meetings 2 times per week, and the TDOEP class.
Okay.
And as part of this agreement, we'll be TICing 2 new cases, night mag number 729016 and 729015.
That's correct, Your Honor. That's our agreement.
All right. Mr. Perez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Jose Perez III.
All right, so what drugs are you using?
I'm using methamphetamine.
All right, how often?
Every month. Every day, basically.
All right, so here's the thing. You got to be honest with me.
Yes, ma'am.
Because they've come to an agreement. I'm inclined to follow it, but in order for me to follow it, I need to give you conditions. So hopefully, whatever your issues are, you can get a control of them. You understand?
Yes, ma'am.
So you're using meth every day?
Yes, ma'am.
All right. Felony drug court is at capacity. But I think you need inpatient treatment, which is what everybody's suggesting you need.
Yes,
so what I can do is I can deny the motion, alter the main conditions, and I'll have you go to SATA And I'll ask probation to make sure that you're still referred to felony drug court. So maybe once you're released from SATF, you can go into felony drug court. So even though SATF will address some issues, I don't think that's going to be enough for you with a daily meth use. I think you'll need felony drug court as well. Do you understand?
Yes, sir.
All right. This is what the court will do then. The court will deny the motion, alter and amend conditions to include SATA with aftercare and a referral to felony drug court. Take in consideration NIMAC number 729-016, 729-015, and there'll be daily sober support meetings until accepted into felony drug court. And I know that seems like a punishment, but until you're accepted in felony drug court, you got to keep your mind busy and you got to keep your mind on your sobriety 100%. It can't get distracted at all, because otherwise you'll probably be back here again for a possession of a meth case. And I understand the only difference from somebody possessing meth who has a drug problem is they didn't get a chance to use it. So understand?
Sure.
Is there anything you need from the court to be successful other than what we've given you?
No, ma'am.
All right. Thank you.
Thank you.
Thank you, Judge.
Thank you. Okay. That is it. Yes, please. Yay, we'll be back on Monday. And you can go ahead and take your break, because I believe Judge Jarrett has that case that she's hearing in the afternoon. I'm not sure. I think it's 1:30 or 2.